Okay, perfect.
I guess we've reached a reasonable number of participants. I guess we can start if you're okay with that, Dr. Natali, Mr.V.Inbavijayan.
Yes.
Thank you. So welcome everyone. Welcome to the Kovise Foundation Conflict Resolution International, in short KFCRI's webinar series. We welcome Dr. Natali Najjar, Mr. Inbavijayan, and Ms. Krithika Bhandari. Today I'll be the host of the session, and Ms. Krithika Bhandari will be moderating, and the lead speaker will be Dr. Natali Najjar. Before we start into the webinar, I would like to talk about KFCRI in 2 minutes. Kovise Foundation Conflict Resolution International is actually differentiated in 2 different wings. One, it is an accrediting body or a training body. We provide accreditations in every field of ADR, that is in arbitration, mediation, conciliation, and even as a tribunal secretary. Apart from this, KFCRI is also an ADR center in itself. We have our own rules in, again, all the fields of ADR, and we have our clauses which can be incorporated in different contexts. Now, with this webinar, I would like to establish certain housekeeping rules. You can find the Q&A box below, in which you can type through this course of this webinar any questions which you have, which will be answered in the last 15 minutes. You can mention any technical difficulties which you're facing in the chat box as well. Thank you. Mr. Inbavijayan, if you would like to introduce the speaker.
Yeah, thank you, Sweta. Welcome, Dr. Natali Najjar. It's very interesting to share the details about a doctor. She is actually a lecturer in arbitration, dealing with the masters as well as PhD scholars, in both jurisdictions, one in France and another in Lebanon. To add on, she is also a senior partner of Ibrahim Najjar law firm, and her activities are quite appreciated in ICC Lebanon, as well as in various law journals and law reviews. Very interestingly, she publishes the Lebanese review of Arab and international arbitration. To add on, she is also an advisory board member of KFCRI. And very interesting thing we had to understand from doctors that she is especially in charge of the arbitration in the Arab countries, particularly the Francophone or North Africa, and we call it MENA, M-A-N-A region. And she is quite popular academicians in this region. To bring out her experience and exposure in arbitrations, she frequently sits as arbitrator representing the Lebanese government before the ITSIL arbitrations, very large and complex investment arbitration cases. And she's also regularly been appointed by ICC, the Cairo Regional Center for International Arbitration, the Dubai International Arbitration Center, as well as many ad hoc arbitrations predominantly. And interesting note about her is that she's promoting a lot of academicians in arbitrations in various jurisdictions, particularly in the Mediterranean region. And I am thankful for her to accept this particularly interesting topic, human resources in arbitration, particularly dealing with this guerrilla tactics. And I thank her wholeheartedly. And I think this particular webinar would be very interesting for arbitration practitioner. And KFCRI and the KFCRI members would be really interested to hear from Dr. Natali. Now I think Krithika can take the turn, and she can introduce the subject and take it forward.
Thank you, sir. So I would like to extend a warm welcome to Dr. Natali Najjar. It is a pleasure to have you here. I will be moderating this webinar, and so the topic of this webinar is human resources in arbitration. That is ethics of parties and arbitrators and how to fight delaying tactics or the guerrilla tactics. Now, so to start with, the use of arbitration to resolve a wide variety of disputes has grown extensively and forms a significant part of the justice system on which the society relies on. Parties and arbitrators therefore undertake some serious responsibilities to themselves as well as to the public. Now, these responsibilities include important ethical obligations, and most of the code of ethics indicates practices to be followed in order to preserve the arbitration process. So I would like Dr. Natali to point out what are the ethics to be followed by the parties as well as the arbitrators, and also what, according to her, are the standards for distinguishing ethical from unethical actions. Also, it would be great if you could stress on the ethics to be followed, not just by the parties, but also the arbitrators while dealing with the guerrilla tactics in arbitration. How to face, face the bad faith opportunities by utilizing legislative shortcomings in order to thwart the efficiency of arbitration. So Dr. Natali, it would be grateful if you could start by giving us some insight as to what is actually meant by guerrilla tactics and how do parties and also arbitrators use them in arbitral proceedings.
Well, first of all, allow me to thank you. First of all, of course, I will thank Mr.V.Inbavijayan for inviting me. And I will thank you too, Krithika, for your very useful and very kind assistance. And thank you for hosting me today and for inviting me. And as I said it earlier to your colleagues before going online, I think that your endeavors and your these webinars are extremely useful, especially in this current situation, and given the fact that first many practitioners have now time on their hands, and of course I would like to also congratulate you on the interesting topics you are being organizing lately on your sites and in these webinars. Of course, my intervention today will be dealing with ethics of parties and arbitrators, and most specifically how to fight against guerrilla tactics in arbitration. Let me first of all tell you that arbitration, like any dispute resolution mechanism that intends to do justice, must have some guarantees. The functioning of arbitration must inspire confidence. And acting diligently within arbitration, whether from parties or arbitrators, is, of course, one of the main functions that is expected from an arbitration institution and from arbitration in general. This is, I will cite a small example for the ICC lately, since the last modification of its rules, does not hesitate to reassess arbitrators' fees according to the time spent in arbitration, which obviously reveals a trend, a very accurate trend in this regard. So as we said it today, our focus will be ethics in arbitration, and more specifically, how to fight against guerrilla tactics within arbitration. What do we mean by guerrilla tactics? Actually, guerrilla tactics may occur when a party resorts to parallel actions and uses legal provisions and legal procedures and court actions in order to thwart time limits and efficiency of arbitration. These tactics are not only they can not only be the ones of parties, they can also be the result of arbitrators' behaviors, and more specifically ex parte, or what we call partisan arbitrators, in arbitration. Why do these guerrilla tactics, they are called also delaying tactics or dilatory tactics, why do they result? Why do they occur? How come they are not sufficiently and properly dealt with in practice? It's actually the consequence, whether desired or not, but it's the consequence of the enlargement of the sphere of autonomy within arbitration, the sphere of autonomy of the parties, or the sphere of autonomy of the arbitrators. Of course, it's better to have a wide economy than a strict one, but this is the price to pay whether we want to guarantee this sphere of autonomy. Of course, we cannot identify all the guerrilla tactics. It would be illusory to think that we can describe what can be the product of the fertile imagination of parties and arbitrators. It's illusory. But however, we can stress on the most common ones, and this is what I will be dealing with. Of course, I will stress also on the ethics that should govern the arbitration, whether relating to the parties or the arbitrators. And this leads me to deal with two perspectives in this regards, as already shown. The first perspective will be the tactics that will be the guerrilla tactics that will be used by the parties, and the second perspective will be the guerrilla tactics and the delaying tactics that will be resorted to by arbitrators. First of all, let me deal with the parties' way of compromising efficiency of arbitration and by resorting to guerrilla tactics. The delaying tactics, the guerrilla tactics that parties may resort to in arbitration are of course very varied. They generally consist in using the legal proceedings concurrently to arbitration in order to benefit from the possible impact of these concurrent proceedings on the arbitration, and in order to delay and to delay the time limits in arbitration. If we try to list them chronologically, of course, we will see that they can occur at several stages of the arbitration. First of all, the most detrimental would be to try to compromise the arbitration agreement in several ways, and try to resort to state courts in order to thwart the efficiency of arbitration agreement concurrently to an arbitration procedure, and to try to benefit from the impact of such court proceedings on the arbitration. The second stage of delaying tactics will be whenever parties will try to compromise the constitution of the arbitral tribunal. And we will be dealing with each of these stages one by one later on. And of course, there are other tactics that can be resorted to within the arbitration agreement whenever a party seeks the support of a court, state court, to arbitration. But these last ones, I won't be dealing with them as they are very detailed, and we don't have probably enough time to deal with them. So we will be finally dealing with two main concerns. But before dealing with these issues, let me tell you that the model law, taking into consideration these delaying tactics, has provided in its Article 5 that in matters governed by the Arbitration Act, by the Anti-Trial Model Law, no court shall intervene except where it is provided for in the law, which means that the Anti-Trial was already aware of this, the threat of these concurrent and parasite actions and their impact on arbitration, and has chosen to exclude all court interventions that are not provided for in the law. And this provision has been resumed by the Indian law, which is, of course, a very a good thing. So this strict intervention of the court system within arbitration is also a very important thing in order to avoid concurrent actions that can lead to compromise the efficiency of arbitration. First of all, let's talk about the disputes around the arbitration agreement. Well, actually, whenever you want to thwart an arbitration proceeding, even if the arbitration tribunal has been already constituted, you will try to reassess the efficiency or the validity of an arbitration agreement, whether before the arbitration tribunal or before a state court. So the first thing that will be done is to resort to a state court in order to examine the arbitration agreement, while hoping that this concurrent legal action will have an impact on the arbitration agreement, as for example, on the arbitration procedure. For example, it will lead to the stay or the suspension of the time limit, and will, of course, will lead to compromise the efficiency of the arbitration. So it's very important to see what will be the conditions that surround these court actions, and what are the impact of these court actions on the course of the proceedings. Let me tell you that, first of all, there are two ways to resort to court: either by a direct action aiming at pronouncing the nullity, the cancellation, and the lack of efficiency of an arbitration agreement directly by the state court, or you can ask the state court to examine the merits while raising a plea of non-existence, nullity, or ineffectiveness of the agreement that base the claim. I mean, it's a matter of nuances between these two kinds of actions. But what is more important to say is the court, state courts, of course, today, it's not disputed anymore that state court, whenever they are seized in order to examine the merits of a dispute, notwithstanding the existence of an arbitration agreement, should refer parties to arbitration. They should not examine the dispute whenever there is an arbitration agreement. This is enshrined in the New York Convention, in the ancestral model law, and in all modern laws and modern systems of arbitration worldwide. This rule does not raise any significant problems anymore. However, the most important thing here is not to see whether the court will refer parties to arbitration and decline from examining the merits of the dispute. The most important is to see whether it is allowed to examine thoroughly the arbitration agreement, notwithstanding the existence of a constituted arbitral tribunal. This is for one. And second point is whether to see whether this court action, this parallel court action, will have an impact on the time limit and on the course of the proceedings, of the arbitral proceedings. And these two points should be absolutely dealt with very efficiently if we want to fight against guerrilla tactics. Of course, resorting to a court to examine an arbitration agreement is not considered as such per se as a guerrilla tactic practically. because it is enshrined in the New York Convention. But all depends on what will be the impact, as said, on the course of the arbitral proceedings. So this is, for example, in India, you have taken the Article 2.3 of the New York Convention and the ancestral model law as is, and without modifying this system. But you should bear in mind that it is not the only system that is that exists worldwide. For example, in France, instead of allowing the court judge to examine thoroughly the arbitration agreement, the court judge is only bound by a provision that invites him to only examine the arbitration convention prima facie without going into the merits of the arbitration convention, without examining thoroughly the arbitration convention. So this is a way, to my point of view, that is more efficient than the convention, the New York Convention, and then the Ancestral Arbitration Act, that could probably stop at this level the contentions and the discussions around the arbitration agreement, because practice has shown that in most of the cases, these parallel actions aim at compromising the efficiency of arbitration, the course of arbitration, and are not well-grounded, and most of them lead to the rejection of the parallel action. But it's an illusion to think that it has no impact on at least the psychology of arbitrators while dealing with an arbitration. So this is very important to try to limit the impact of such actions on the course of arbitration. The second point is what will be eventually the impact of remedies against an arbitrator's or a tribunal, arbitral tribunal, decision on jurisdiction. And what will be the remedy? I mean, the impact of a remedy, a recourse against these decisions on jurisdiction on the course of arbitration. Let's suppose we have an arbitration proceedings, and we have an arbitral tribunal that has rendered a decision on jurisdiction, and one party, in order to benefit from the impact of an appeal against this decision, will go to court in order to let's say, benefit from as said, the consequences of such action on the course of the proceedings. So it's very important to limit also the impact of parallel actions against jurisdictions, orders, or awards on the course of arbitration. For example, in France, they have just completely rejected any recourse against the decisions on jurisdiction during the pending proceedings. They only allow the recourses with the arbitral award at the outcome of the arbitration. In India, the ancestral model law has been modified in order to stop these kinds of parallel actions, which is very appreciable and which is a good thing. Whereas the ancestral has chosen another path in order to limit the guerrilla tactics. It has chosen that to allow court actions before the outcome of the arbitration against decisions or on jurisdiction, but has on the other hand has chosen to allow arbitrators and arbitral tribunal to assess whether these court actions could lead to the suspension of the court of the arbitration proceedings or not. Both systems can be defended, but I, for myself, would be more partisan of a way of completely stopping any action that could lead to seize the courts while the arbitration is pending due to the disturbance, the turbulences that can have impact on the arbitrator's psychology. So this is also very important to stress on. Also, the last point, which is the incidence of the constitution of the arbitral tribunal. Well, there are many ways for parties to benefit from concurrent and from parallel procedures in order to delay time limits in arbitration. First of all, and I have witnessed that in many cases within the jurisdictions I deal with. For example, some parties can request the appointment of an arbitrator to a judge other than the one that is located at the seat of arbitration, which means that, for example, I will give you an example. Let's say the arbitration the arbitration seat is in India. One of the parties is, let's say, Lebanese. It will seize the Lebanese judge in order to appoint an arbitrator, whereas the seat of the arbitration is in India. This will lead automatically to very contradictory decisions on matters of arbitration, and will compromise later on the efficiency of any eventual arbitral award elsewhere, because if the Lebanese courts will accept and will not decline their jurisdiction, there will be two jurisdictions that will deal with the same issue, and will lead to contradictory decisions. So this is something, of course, it's very important to limit the assistance, the support of the state courts only to the ones that are located at the seat of the arbitration, and not to allow a international extraterritorial jurisdiction of the supporting judge. So this is something, of course, that is very important in order not to compromise any future arbitral awards on this issue. Again, also, the refusal to constitute an arbitral tribunal can lead also to many complications. I'm thinking mainly on the same issue that I have recalled a while ago. That is, what would be the consequences of such refusal if you resort to a supporting judge? Well, if you allow this judge to reassess the arbitration agreement, well, this will be a hard blow on arbitration, because this means that whenever you refuse to implement the arbitration agreement, you will be allowed to, you will allow the court, the state courts, the assisting judge, to examine, to have a sort of admission within the arbitration process, and to reassess the arbitration agreement at this stage, which can have, of course, negative effect on the course of arbitration. But mainly, this is why I also would prefer to limit the extent of the control of the assisting judge to only a prima facie control of the arbitration agreement, which is not the case in several jurisdictions now, not even in the arbitration, the Ancestral Arbitration Act, sorry, and it's not the case also in India, where you allow a thorough control of the arbitration agreement at this stage of arbitration. And also, finally, you should, of course, limit the appeals against the decisions rendered by the supporting judge. And most of all, we should, if we want to fight against guerrilla tactics, we should also take into consideration the challenge requests, the challenge action, the challenge contentions of an arbitrator. Of course, to challenge an arbitrator is not considered as such as a guerrilla tactics, but practice has shown that in for example, Gary Bourne in his book, if you examine the figures he has put forward, you can examine that on 335 cases between 2004 and 2012, only 35 applications were successful. That means only 11% on challenge requests were successful, which confirms the idea that in most of the cases, challenges have aim at reconsidering the efficiency of the arbitration tribunal, and a party wishes probably in that way to appoint a more understanding arbitrator than the one that has been appointed by its opposing party. So it's very important to deal with these actions as most often as guerrilla tactics more than really legitimate actions. So of course the impact of the challenge on the arbitration procedure is of a prime importance, because if the impact of a challenge is the automatic suspension of the course of the proceedings, this will lead to, of course, to encourage such actions, which of course should not be the case. And so the most important is to allow the arbitral tribunal to move forward with arbitration proceedings, notwithstanding the challenges that have been brought forward before the state judge. The Indian system is very interesting. It has resumed the ancestral system. In India, you submit the challenge request first to the arbitral tribunal, and if it's up to the arbitral tribunal in a collegial way to examine the challenge request, and the decision of the arbitral tribunal is subject to a setting aside procedure before the state courts if the challenging party is not satisfied with the decision. And the most important thing is that the setting aside procedure against the decision of the arbitral tribunal has not, as for effect, does not impact on the course of the proceeding, which is a good thing. So the second point is that the challenge should not also lead, once the arbitrator has been removed, should not lead to a repetition of the oral and the written phases. Otherwise, you will have to restart from scratch the whole procedure, the whole proceedings before the newly constituted arbitral tribunal, which could be a hard blow here again against the course of the proceedings. So this again should be dealt with whenever you deal with the challenge request and the challenge of an arbitrator. So this is globally, this is what I can say with regard to the parties' tactics. Now the new aspects that we can notice in arbitration are the delaying tactics and the guerrilla tactics of arbitrators. This is a phenomenon that is very rarely taken into consideration in nowadays arbitrations. Why? Because the deterioration of morals within the arbitral tribunal is something that has expanded very recently, but it is now a very accurate and very acute, problem, and that should be dealt with in practice, because we have, as you know, two sets of schools with regard to the behavior and the ethics of arbitrators. You have the school that says it's more the American school, the pragmatic school, that says that arbitrators should, at least the co-arbitrators, should not have the same independence and impartiality as the chairman of the arbitral tribunal. So this is we should deal with the situation as a an obvious practice, and it should be, we should try to deal with the situation as a fact. Whereas you have a civil law school that says that no, arbitrators, whenever they are co-arbitrators or the chairman, should all behave with ethics and should be independent and impartial with regard to parties. So we have two sets of schools. And of course, whenever you have a school that allows a co-arbitrator to behave in a partisan way, you should expect to have a partisan behavior of arbitrators within the arbitral tribunal. So actually, what we will see is that most of the remedies now available in the worldwide systems, whether in the ancestral derived systems or the civil law systems, is that these remedies are not efficient enough to deal with these behaviors, and that some new trends should be followed in this regard. And we can notice then that many arbitral institutions are taking these behaviors into consideration. First of all, what are these behaviors? What are the practices we can notice in this regard? We will describe these practices and see the remedies available, and we will at the second later on examine if the sanctions traditionally available in this respect are sufficient. First of all, the description of the behaviors and the remedies. The first very common behavior is to witness a refusal of an arbitrator to attend hearings in order to in order to allow the party that has appointed him to benefit from a certain time limit, from the complications, etc. So the refusal to attend the hearings is becoming common practice now. So, well, what we see is to remedy this behavior, what is available now? If you want to deal with the situation, generally, what your option is to remove this arbitrator, to try to remove this arbitrator that refuses to accomplish his mission, and to try to replace this arbitrator. But what you should bear in mind that a replacement and a removal process could be very prejudicial and could be a blow on arbitration. Why? Because if this intervenes at a very advanced stage of the arbitration, this will lead to compromise all what has been already accomplished within the arbitration, and it will lead sometimes also to the repetition of the procedures if you appoint a new arbitrator. So this is not an efficient way to deal with this situation. So that's why after the Iran-US claims that were very well known, practice has come up with a new trend, a new way to deal with this behavior. And this has also, it has been enshrined in several arbitration arbitration rules of renowned institutions such as the ICC, the LCIA, the AAA, and even the ancestral rules. What is it? It is actually to allow the arbitral tribunal to continue the proceedings with what we call a truncated tribunal, notwithstanding the refusal of this arbitrator to attend the hearing, without resorting to his removal and replacement, in order not to delay more the arbitral process. So this is a very efficient way also that should be taken into consideration whenever there are arbitration rules. You have an institution, for example, at the KFCRI, you should probably take this issue into consideration in the rules, following the example of many renowned institutions elsewhere. But there are also other sets of behaviors. For example, the arbitrators, an arbitrator, in order to favor the party that has appointed him, whenever he sees that he is close to a solution that is in the disadvantage of the party that has appointed him, can resign for delaying purposes. So this resignation can also be a very hard blow on to arbitration if it occurs at the very advanced stage of the proceedings. And of course, it's also very it's detrimental if it occurs after the closing of the proceedings. So this is something it's a very serious thing to be taken into consideration. And this is why also the trend has been lately, namely in the ancestral arbitration rules of 2010, that the new trend is to allow the arbitrator, the arbitral tribunal, to go on with the proceedings, notwithstanding this resignation, of course, also by allowing truncated tribunals, even if this will lead to the rendering of the award without the participation of this arbitrator, but on the sole condition that this arbitrator be placed in a position to submit his views and to be allowed to participate. But if he resigns, this should not lead to compromise the efficiency of the process of the rendering of the arbitral award. So this is something also that should be dealt with and should be taken into consideration. Lastly, also, there are some behaviors that can occur while drafting the arbitral award. This is something very common. You can, for example, see an arbitrator that refuses to take part into the deliberations. Most of the arbitration systems worldwide require that the arbitral tribunal deliberates, but actually none of them examines the situation where one of the arbitrators refuses to deliberate. Here again, the same thing should happen. It means that we should allow the arbitral tribunal, after allowing this arbitrator to submit its views on the issue, on the case, to allow the arbitral tribunal to move forward and not to replace, of course, and to seek the replacement of this arbitrator, and of course to render the award notwithstanding this behavior. And the last point will be with regard to the behavior, the refusal to sign an arbitral award. Of course, the Indian Arbitration Act, resuming the ancestral arbitration model law, they require that the award be signed by the arbitral tribunal, and whenever there's one arbitrator that fails and refuses to sign, that this be mentioned, and that the arbitral tribunal goes on with the award, even if one of the arbitrators refuses to sign. However, practice has shown, and it's precisely in these Iran-US claims that have revealed a very accurate aspect of this issue, when practice has shown that sometimes whenever one arbitrator refuses to sign, the remaining two arbitrators could have divergent views on the merits of the case. So why do you want the chairman of the arbitration tribunal to sign the arbitral award and to rally the view of the other co-arbitrator whenever he disagrees with this other co-arbitrator? So that's why practice has shown, and many arbitration systems, and recently the French system, the French law, has allowed the president of the arbitral tribunal, the chairman, to sign alone the arbitral award, even if both of the co-arbitrators do not sign the award with him. So this is a way also of allowing to of preserving also the views of the chairman of the arbitration tribunal, which is extremely important that because we know that it's the chairman that will finally have the leading voice in settling and in examining the merits of a dispute. So this is what I had to say with regard to the behavior and the remedies that are actually nowadays available, but of course not sufficiently elaborated in order to address the problems that we are facing currently in practice. So yes.
So as rightly said, ma'am, these unethical activities would put the arbitration proceedings and delay the arbitration proceedings should obviously be redressed. So so what are the remedies or sanctions available for dealing with such tactics or such delaying practices? And are these sanctions efficient to address the bad faith behaviors of the arbitrators?
Yes, actually, the sanctions that are available are very traditional ones. You have either the removal, and we have seen that the removal of the arbitrator is something that is not something, it's something that can have a negative impact on the course of the proceedings, especially if the removal can lead to the repetition of the written and oral phases, especially that the removal will lead to the replacement with all the delays that occur with this replacement. And of course, you know, but even the removal in some system is not allowed. I mean that the removal, of course, is something important, but in some systems it's even not allowed. And whenever it's allowed, it's not beneficial for the course of the proceedings. The other sanctions is the responsibility, and I will have a word on this responsibility, because generally arbitration institutions have well, they consider that the arbitral tribunal and the arbitrators should have immunity. All systems do not agree on this immunity, because, for example, if the Anglo-Americans and the British are probably in favor of such immunity, and which is completely understandable, the civil law systems, and most, for example, in France, you have authors that consider that it's not up to the arbitration institution, and it's not up to these institutions to recognize immunity, because only the law can do so, and because of its contractual origins, this cannot be recognized. But beyond these discussions, we should say that immunity is something very important, especially that we witness here and there some very detrimental and some very efficient guerrilla tactics that lead to compromise the autonomy of arbitrators whenever dealing with the merits of disputes under the threat of actions and civil or criminal actions. So immunity is a good thing whenever it does not also encompass the misconduct, the intentional misconduct of an arbitrator. If the intentional misconduct is not covered by immunity, it's a good thing. However, civil and criminal liability, of course, is something that should be enshrined in all systems. However, you should bear in mind that these liabilities should only occur in very, very serious cases. Otherwise, arbitrators could be deprived from their freedom of mind and spirit in order to assess the merits of a dispute. I will recall a very famous case that I have been involved in that led to criminal liability for very futile grounds, which is something that is completely I mean, is not absolutely not welcome in arbitration because of its impact on the behavior of arbitrators. So criminal liability should be reduced to to its very strict limits. For example, whenever you deal with corruption, intentional corruption, or whenever you deal with denial of justice, without, for example, encompassing cases that should not be, I mean, for futile reason, as for example, if I witnessed a case where it was only because the arbitrators have set the seat of arbitration in a foreign country. This is something completely, I mean, of course, it's very prejudicial for arbitration and should be abandoned. So here again, it's very important to bear in mind the need to preserve autonomy of arbitrators and to limit to its extreme limits civil and criminal liability to only things that are really grounded and really legitimate. So this is what I had to say, and thank you. Any questions on that?
Dr. I think we have around 8 minutes left. So
yes, but if someone has questions or something.
So a question from Jafar Ismail. What are the provisions can be made to avoid guerrilla tactics?
Sorry, excuse me, can you repeat the question?
What are the provisions which can be made to avoid guerrilla tactics?
What are the what?
The provision, any type of provision.
Provisions, yes. The provision in order to fight against guerrilla tactics. At several levels, you have provisions at the level of the arbitration agreement, at the level of the constitution of the arbitral tribunal. If you have some provisions within your arbitration act that can depends what has been foreseen with regard to the course of the proceedings at each stage, at each level, and even the Untitled Arbitration Act took to a certain point, because as we know, the Untitled Arbitration Act is the model law has only enshrined the most common practices, but there are more advanced practices than the Untitled model law in order to fight against the tactics. It's of course we don't have time to examine all the provisions, but you have lots of provisions that can be enshrined, whether on behalf of the parties, with the parties' perspectives, or whether on the, and I have pointed them out whether on the arbitrator's perspective, and I have pointed them out while dealing with my subject. Of course, if someone needs any advice on this issue, I can be of help. But of course, we cannot. At all levels, at all stages of arbitration, we can have provisions that help fighting against guerrilla tactics.
Yes, ma'am. Can I go to the next question, ma'am?
Yes, sure.
Yeah, so the next question is from Ms. Saranya. She asks that if one of the party to the arbitration wantedly delays the arbitration process and keenly acts to disturb the process, how to handle the situation?
Well, it depends what means she's resorting to. It depends on how this party is trying to compromise the efficiency of arbitration. Depends at what stage, depends what's the court action it's taking, and it's of course it depends on the state system, the Arbitration Act, and what is available within this Arbitration Act. There are no there are such multitude, such a variety of guerrilla tactics. And you know, the practitioners have a very fertile imagination. I'm just pointing out some very common ones, but many of them, all rules can be deviated from their original aim. So everything can be distorted in somehow. Depends what you're, for example, if you, I would love this person that's asking the question to be more precise. I will tell her how the tactic will be resorted to in practice. But it's, of course, it depends on at what stage, what court proceedings she's resorting to, what legal provisions she's relying on. So it's very, depends. You don't have one prototype in mind.
Yes, I'm moving on to the next question. So this is by Mr. Deepak Narayan. He asks that in India, since many arbitrators are still not properly trained, which often necessitates court interventions, how can we find a balance between legitimate court interventions and delaying tactics adopted by the parties to avoid guerrilla tactics?
Yes, this is a very important issue because whenever you appoint an arbitrator that hasn't got enough experience and that hasn't been that doesn't acknowledge properly the basic rules and the basic fundamentals of arbitration, unfortunately, this can lead to very successful means of guerrilla tactics. And how to, I mean, the only impact of the lack of experience of an arbitrator is on the way this arbitrator deals with these tactics. It doesn't have another kind of impact. Now, if you want to remove this arbitrator, once appointed, this will lead to lots of complications. So the best is not to appoint at first, at the beginning, not to resort to arbitration that don't have enough experience and that are not sufficiently sufficiently experienced with regard to these kinds of tactics. Removing them will probably complicate things, but here again, it's a very delicate balance between the need not to resort to court, not to consecrate the court admission within the arbitration process, and on the other hand, the necessity of having an efficient arbitrator that knows how to deal with the situation. This is a good question, and unfortunately, it is a very big problem in practice. And what my only advice would be: please choose the appropriate arbitrators before resorting to arbitration. Because once you have, there is a French saying that arbitration is worth as much as the arbitrator. So it's very important to resort to experienced arbitrators in order to avoid also and to overturn these kinds of tactics.
Thank you, ma'am. But I think due to the shortage of time, we'll have to.
Exactly.
I would just like to tell that the rest of the questions will be answered in due course. And if there's any question, you can send it across to kfcri.ad@gmail, and we'll be forwarding that to the speaker. So I would just like to sum up and ask Mr. Inbavijayan, sir, to give the vote of thanks. Thank you, sir.
You have muted your microphone, Mr. Inbavijayan. Yes.
Now it's audible?
Yes.
Thank you, Dr. Nathalie. It was really not a guerrilla affair, but it's a guerrilla tactics in arbitration, what we just heard from you for the past 1 hour. Interestingly, I think there are a huge number of questions, more than 25 questions, out of which reasonable numbers have been answered. Anyway, it will be shared through our email, and you can get that questions and you can ultimately revert back. One very interesting thing I wanted to share at this point of time. You have really highlighted that the choosing the effective arbitrator, the right arbitrator, solves the entire issue. To this extent, I feel that organizations like KFCRI is doing that task. We are trying to bring an effective arbitrators so that the persons should know the law, the procedure, and obviously they should not come under the purview of this guerrilla tactics. They have to be real professionals, full-time professionals who have to sit as arbitrator, and ultimately that is going to solve these issues. When it comes to the parties, I think the soft laws, the IBA guidelines on party representation, as well as the IBA code of ethics when it comes to arbitrators, these two are the really good materials, soft law materials, which I think can be rightly taken by the arbitration practitioners as well as party representatives. With these few words, I think that I have the wholehearted thanks to you, sparing a valuable weekend with us, particularly it's a lunchtime in India, exact lunchtime between 1 and 2. Very interestingly, it is food for thought, what you are given. And as a KFCRI, we'll take this message seriously, and we will ultimately bring it to the to start with the members. And we seek your continuous support in promoting the concept of arbitration practice and the promotion of arbitration, particularly people who are interested to become arbitrators. And our guidance should continue in all the maximum arena, whatever possible. And this is just a beginning for us in the midst of COVID-19, wherein literally we are in the lockdown till May 3rd. And thank you once for all. And I'll request Swethan to give the further say webinar details and other activities.
Thank you, Mr.
Thank you very much. Thank you all.
Thank you again, Dr. Nathalie.
Thank you.
My foremost thanks to the entire KFCRI team who's been working behind the curtains as well. Just a bit of logistics. So we have our next webinar posted on the 30th. It is by Dr. Krithika R. He'll be talking on the topic, what makes a good commercial mediator. The links will be shared to everyone via mail and by messages through WhatsApp and Facebook. There'll be the recorded version of this same webinar on YouTube uploaded within a few hours. If you feel like sharing it or viewing it again, please do so. And for the unanswered questions, you can please send an email to the email mentioned in the chat box. That is kfcri.adr@gmail.com. We will try to redirect it to the speaker and answer the same. Thank you so much for joining us.
Thank you too.
Thank you.
Thank you very much. Thank you.
Thank you.